Ladies and gentlemen, welcome to the National Constitution Center. As many of you know, we are the only institution in America chartered by Congress to increase awareness and understanding of the U.S. Constitution on a nonpartisan basis. Excellent. My name is Lana Ulrich. I'm the Senior Director of Content here at the Center. And welcome to tonight's program. I'd like to start off by thanking all the members in the audience. We cannot host programs like the one we're hosting tonight without your support, so thank you so much. For those of you who are new to the center, we welcome you. It's great to see you here, and if you have any questions about becoming a member, you can visit the membership table outside in the lobby after the program is over. Before we begin tonight's program, I just want to make one quick announcement about a newly added program that we just released tickets for tonight. On the evening of Monday, October 7th, we are hosting former Secretary of State Hillary Clinton and her daughter Chelsea. They're going to be here discussing their new book, The Book of Gutsy Women, Favorite Stories of Courage and Resilience. Tickets just went on sale, and I'm sure they'll go quickly, so visit constitutioncenter.org/debate to purchase tickets for that program. With that, I am delighted to welcome tonight's guests for our conversation regarding whether or not the Supreme Court's decision in Roe should be overturned. Sitting to my left is Kathryn Kolbert, who recently retired as the Constance Hess Williams 66th Director of the Athena Center for Leadership Studies, Professor of Leadership Studies, and Professor of Professional Practice in the Political Science Department at Barnard College. In 1992, she argued the landmark case of Planned Parenthood versus Casey before the Supreme Court. And since then, she's worked for and overseen different organizations such as People for the American Way and the Annenberg Public Policy Center at the University of Pennsylvania. Mary Ziegler is the Stearns Weaver Miller Professor at Florida State University College of Law. She's an author historian and has written numerous books and articles on this topic, including After Roe, The Lost History of the Abortion Debate, and Beyond Roe, Roe versus Wade and the Fight for Privacy. And her new book is titled Abortion in America, A Legal History, Roe versus Wade to the Present, and is forthcoming soon. And finally, we have Kathryn Glenn Foster, who is President and CEO of Americans United for Life. In addition to her work at AUL, she serves on the boards of Then There Were None Christian Legal Society in DC Metro Chapter, the Family Policy Alliance, and the Rockville Women's Center, as well as serving as a senior fellow in legal policy at the Charlotte Lozier Institute and a fellow with the James Wilson Institute on Natural Rights and the American Founding. Please join me in welcoming our three panelists. Okay, so we're here to discuss the future of Roe. And over the past year or so, maybe a little bit longer, there's been a number of state laws and activity at the state level about reproductive rights. Some state activity has been to go far in protecting reproductive rights, and other states have passed laws restricting access to abortion. So Mary, I'll start with you since you're the historian here. And can you just start by telling us a little bit more about what's been happening over the past year and putting that activity in historical context? You know, why is this happening now, and what can the history of the debate over Roe tell us about what the states are doing currently?
Well, I think what's changed, the obvious thing that's changed is the membership of the Supreme Court. So we now have a presumed 5-justice majority to overturn Roe. And I think also what you've seen is in many states, control of all three branches of government by one party that enables legislators to pass this kind of law. I think what's striking, though, is that you also see a break from the strategy that groups like AUL pioneered, which was to sort of chip away at Roe gradually and give what the Supreme Court would be expected to accept in terms of restrictions that would be the most likely to be upheld. You see, and also I think to some extent restrictions that would play well on election day. And you see, I think, in a lot of states, like I live in Florida, I live very close to Alabama, you see states going much further than that, much more quickly than that. So there are, I think, more divides about what the court is going to be willing to do So we're in a moment historically where there's a debate, I think, within the pro-life movement or the anti-abortion movement, depending on your perspective, about what the best strategy is going to be. And I think that's in part because until now there's been a uniform target on that side, which was Roe v. Wade, and we're already now very much in a moment where we're thinking about what the world is going to look like after Roe v. Wade. I think I imagine probably everyone on the panel thinks that that's what's coming, and that there'll probably be disagreements about how and why. But I think that's the historical moment we find ourselves in. And in part, the history also, it's helpful to realize that the goal has always been, I think, understandably for people who oppose abortion, to ban abortion, not to ship away an abortion, not to let states decide about abortion, but to create a right to life that would make abortion illegal. And you're starting to see, I think, in some states asking for what they want and hoping that the Supreme Court will allow them to seek it, as opposed to catering to what the justices are presumed to be willing to do, or what voters are presumed, at least voting majorities are presumed to want.
Mm-hmm. So Kathryn, Mary mentioned AUL and kind of what's been going on at the state level in terms of the strategy. And so for instance, in Alabama, as you mentioned, there was a full abortion ban, I believe, that was passed when the governor signed into law the Alabama Human Life Protection Act. And I just want to read a little bit from her signing statement to help us kind of understand what they were thinking when she signed that. She said, Governor Ivey said, no matter one's personal view on abortion, we can all recognize that at least for the short term, this bill may similarly be unenforceable. As citizens of this great country, we must always respect the authority of the Supreme Court, even when we disagree with their decisions. Many Americans, myself included, disagreed when Roe versus Wade was handed down in 1973. The sponsors of this bill believe that it is time once again for the U.S. Supreme Court to revisit this important matter, and they believe this act may bring about the best opportunity for this to occur. So is that really kind of the motivation behind passing these laws? Is it to sort of directly ask the court to kind of revisit that, or is it more of a chipping away, as Mary mentioned, with some of the other restrictions that have been put into place?
Well, you can't really understand Alabama without also understanding the flip side, states like New York. As you mentioned, you have a lot of people, a lot of constitutional scholars, a lot of attorneys, a lot of the public looking at the makeup of the court, seeing possibly changes there. We don't really know how those play out. Looking at public polling on abortion, and particularly on some restrictions or some protections for women, things like health and safety standards, informed consent, full informed consent, things like that. And also looking at the abortion rate, which is currently the lowest it's been since before Roe v. Wade. Also noting, which I think even more important than that, the abortion rate among unintended pregnancies. And looking at the increasing percentage of women who may not have planned to get pregnant, may not want to be pregnant, but still are not choosing abortion. And so looking at all of these factors, you see that when Roe v. Wade is overturned, if it's chipped away at, no matter what the situation is, we do expect that this issue would return to the states. Mm-hmm. And at that point, we would expect a certain number of states to follow a more New York type path, a certain number of states to follow a more Alabama type path, and then most states would be in the middle, passing perhaps some health and safety standards, some informed consent, some other restrictions, but not going so far in either direction. And so it's not surprising that this year, more than ever, states are taking a look at this and are increasingly introducing bills and increasingly passing some of these bills into law that will, whether they go into effect once Roe may be overturned or provide some level of protection now, you're seeing that, that there's this kind of movement happening.
So Kitty, you argued Casey, and I think I've read interviews where you said you were a little surprised at the outcome, but nevertheless the outcome was that the court upheld Roe and then created the undue burden standard. And so I'm curious about your reaction to kind of what's happening now. Is it surprising that, you know, a couple decades after Roe and Casey, that there is talk about it kind of going back to the states versus, you know, staying as a fundamental right, or, you know, what's your sense of kind of what's happening?
Well, so in the days before Casey was argued, we were very much in the same circumstance we are now, which is state legislatures in those days. I was in 44 states in the 2 years before Casey, all of whom took up abortion bills. There were about 800 anti-abortion bills introduced. Why? Because they thought the Supreme Court was prepared to overrule Roe. Same thing is happening now. The biggest, at the time that Casey went to the Supreme Court, we fully expected the court to overrule Roe. And in fact, let me just be really clear, they did. In the first, you argue a case and then the justices go back to their conference and they take an initial vote on the case. In Casey, the initial vote was 5-4, overruling Roe by the most extreme standard, that is adopting what we lawyers call the rational basis test, permitting states to do everything, including criminalization of abortion. Justice Kennedy, at the last minute, over a month later, changed his vote when he more fully understood not only the implications of that decision, but frankly, how that affected the institutional integrity of the court. And so we are now at the point where I don't think the current justices will be as brave as Justice Kennedy. I will fully predict, unlike my adversary here, this court is prepared to overrule Roe and return the matter to the states and permit recriminalization of abortion. And why do I say that? Because they have not, they've been very cavalier about stare decisis since Gorsuch has joined the court, the two latest justices. And more than anything, everybody says, but Justice Roberts, he's going to save the day, right? He was the good vote on healthcare reform. Justice Roberts is not going to save the day on abortion. He was very much a student of Justice Rehnquist. He was a clerk for Justice Rehnquist. He believed in Rehnquist's views on most of these issues, and it was Justice Rehnquist who wrote the opinion overruling Roe. So in my view, it's absolutely clear Roe will be overturned. We will return to permitting states to recriminalize abortion. The only question in my mind is when, and I think this court is politically savvy and will wait until after the 2020 election to do this. Okay, so what does that mean for all of us? It means that the issue of abortion will return to the states. Currently, there are 22 states fully controlled by the Republicans, what I call trifecta states. 14 states fully controlled by the Democrats. Now, unlike the Republicans, Democrats don't always fall in line, and so it doesn't seem to me that there's actually a pro-choice majority in those 14 states. I wish there were, but I don't really think there is. In contrast, it seems to me there is an anti-choice majority in the 22 states. So at a minimum, within a year following the overturning of Roe, we're going to see 22 states in this country criminalize abortion or take such extreme measures that means that abortion will be unavailable for women. The second thing that will happen is I think we will begin to see more attention to state legislatures and who becomes a state legislator. And if I have one word of advice for people in this audience, is if you care about abortion rights, if you care about preserving women's access to legal procedures, you gotta care about who's on our state legislature. And in Pennsylvania, we're very close to being able to retake that by the Democrats. And I think we need to pay strong attention to ensure that our state legislatures not only are pro-choice, but are controlled by the party that is willing to enact protective legislation.
So Mary, you mentioned that the timing of it is now based around who's on the Supreme Court, and so the court has not ruled on the merits on an abortion decision since Justice Kavanaugh has been there, but he did dissent in the June Medical Services versus Gee case, where I think that was about admitting privileges for doctors in Louisiana. And so was there anything about his dissent there that might tell us a little bit about how he might rule, or do you agree with basically what Kitty's saying here in terms of the outcome?
I think all of us, I can't speak for Kathryn, but my assumption is that all of us assume that the court will probably eventually in form or in name overturn Roe. I'm not sure I agree that it will happen as quickly as Kitty is saying. I think if you can take anything away from Justice Kavanaugh's And it wasn't, the court at the moment, it pretty quickly will be having its long conference and deciding whether to take June Medical on the merits. They haven't done that yet. So this was just a decision about whether Louisiana's admitting privileges law would go into effect. And Justice Kavanaugh dissented from the court's decision to block the law from going into effect. And I think he seized on what I think is one vehicle that you'll see the court probably use, which is that the undue burden test that came out of Casey has always been ambiguous. And even in its new kind of renewed form, post-2016, after a decision called Whole Women's Health versus Hellerstedt, it's very much based on the facts on the ground. And so the argument in June Medical was basically the court has seen this law before. This is exactly the law the court struck down in 2016. This is sort of insulting the court's intelligence that we're even having this conversation again. And Kavanaugh said, but wait, the facts are different. Louisiana isn't Texas, which was the case in Hellerstedt. There's not enough proof of a variety of things about abortion access. And that's a logical vehicle. If this is a court, I assume if there is a barrier right now, or any kind of hesitation, I would assume, on this court about overturning Roe, it's optics and politics. It's not on the substance. You would assume that if the people who vet Supreme Court nominations are doing their job, that everyone on the court on the merits thinks that Roe should go, but they might be worried about doing it in a way that looks partisan, or doing it too quickly, or doing it in a way that jeopardizes the results of the 2020 election, or doing it in a way that makes the institution or they themselves personally look bad. You can do a lot with the undue burden standard without saying anything about overturning Roe, without even saying you've overturned the 2016 decision, just by saying that the facts on the ground are different. And I would expect that that would be where we would go immediately. I don't know how long we're going to stay there, right? I mean, I think that there will come a point, if you bring, for example, a law saying, you know, we're going to ban abortion at 6 weeks after a woman's last menstrual period because a fetal heartbeat has been detected. It's really, I mean, you can't with a straight face say that that's not an undue burden under any of the court's precedents. So sooner or later, if the court wants to let the states do what they want and not limit it, there's going to have to be a direct encounter with Roe and Casey. But my reading of Justice Roberts and Justice Kavanaugh is that that might take a while, and they might prefer these sorts of more fact-driven, and also, by the way, harder to understand, right? If you're concerned about optics, I mean, it's hard to explain what's going on with that. So if the goal is, if you think Roe is wrong and you're trying to move beyond it, you can get a way toward doing that without the potential political fallout using the undue burden standard. So that would be what I would expect to see next.
So, Kathryn, yeah, I'm curious about, so there's different kinds of state legislation that's being passed. There's the Alabama law, which is more of a ban. And then there's the Louisiana law, which deals with admitting privileges, and it's more of a fact-based analysis about whether this creates an undue burden or not. So I'm curious about how, for instance, if you were to challenge the Alabama law, wouldn't a lower court just have to automatically apply like Roe and Casey? And then if it got appealed to the Supreme Court, they could just not hear it. And so it might not even get there versus a more fact-based case under Casey or the Whole Women's Health versus Hellerstedt decision, where it might involve a little bit more about, okay, let's look at the factors and what's happening. So I guess I'm curious about how that almost outright ban could even make it to the Supreme Court, and then what's your take on the sort of fact-based analysis that Justice Kavanaugh employed in his dissent in Gee?
Sure. Well, first of all, I wouldn't expect that an Alabama-style law would be a case that would be taken up by the court in the near future. And I don't think there are many legal scholars who would believe that. Simply, well, for a lot of reasons. I don't think it would necessarily get appealed up to that point, and I don't think that's the kind of case that the court is looking for right now. We've been seeing some of the cases that they have declined to hear recently. There was a recent per curiam on a fetal remains law out of Indiana, where they're looking at these more fact-based issues. And in the wake of Hellerstedt in particular, with this kind of balancing test idea where really any federal judge is now able to go into the fact that the sort of sociological details relating to a law, looking at how the impact or the supposed impact on women, and then make a decision and potentially strike down a law. And so it really is going back to the idea of the Supreme Court and the entire federal bench as the National Abortion Control Board, looking very much at the facts of a situation rather than the Constitution, rather than the precedent that they really should be turning towards. And we saw that in Texas, and I would expect that we could continue to see that going forward as courts, and especially some of the lower courts, are trying to find a way forward post-Hellerstedt.
Could you, if you have any reactions or thoughts to Kathryn's points?
Well, let me just be clear here. You do not need a ban to overrule Roe. Any law which restricts a woman's access to abortion presents to the court the question of what's the appropriate standard by which courts will evaluate abortion laws going forward. In Casey, the court could have reduced us again to rational basis standard of review. That's lawyer speak for allowing criminalization. And in any case, whether it is a restriction or a ban, that same issue is before the court. So I don't think, let me just be clear here. I think it's really a mistake for us to believe that the debate is between regulation and total bans, okay? Either present that issue to this court can use it to give states, again, the power to criminalize abortion. That's what we're talking about. And many states will do that when given the chance. Why? Because they are controlled by a majority that believe that is the appropriate thing to do. And the notion that both the rule of law and moderation will prevail in this particular political climate has gone away. Many of the state legislatures that are controlled by trifecta Republicans have gerrymandered seats. These are not people who care or who feel in fear of losing their seat in most of those 22 states. So they will be extreme if the political winds call them to. And the same thing with your assumption that a lower court judge is not going to go against current US Supreme Court precedent. We have seen the most radical group of people appointed to the federal bench that we have seen in the last 25 years. These are not, they wouldn't even discuss whether or not they thought Brown versus Board of Education is the appropriate law of the land, okay? So these are radical judges. They will strike down a bill or they will uphold a bill banning abortion and force it to be appealed. And I think that we do ourselves a disservice to believe that this won't happen. And the only reason I'm so emphatic about that is because now is the time to take action. And the appropriate action to take is to start supporting state legislators who believe what you believe. Whether you're against abortion or whether you're pro-choice, the question of how abortion is regulated going forward, whatever we believe, will be determined by who sits in Harrisburg and who sits in our state capitals. And therefore, it is our obligation to think the most dramatically, to think that this could happen, because now is the time to make that change. Otherwise, it's too late. Okay? You've got not only trifectas in 22 states, you've got 9 states that have trigger laws. Day the court reverses Roe, there's automatically a law in the books that says you return to the prior statute. Now, that may not be appropriate, that may not be legal, but it's going to require a lot of litigation. And so it seems to me our best bet going forward is to start taking proactive measures now.
So it sounds like there's a kind of a consensus that eventually the court is at least going to chip away to some extent or directly overturn it. It's just kind of a matter of time.
No, that's not what I'm saying. I'm not saying they're going to chip away. Okay, chip away they already did. They did that in Casey. Okay, they went from the highest level of constitutional protection to a middle standard. They've been chipping away for 25 years. Many states have 2 or 3 abortion providers. Some states only have 1. We are done with the days of chipping away. This court is going to take more dramatic action.
Kathryn, I'm curious if you have a response to that point and your thoughts about the chipping away versus just the complete overturning.
Sure. First of all, I don't know how quickly the court may take action on this. We do know that most years, certainly about half of the years plus since Roe, we have seen the court take up a case on abortion. We have seen in large part chipping away for close to 50 years now. And that really indicates how unsettled Roe is. It indicates that, that it's unsettled for the court, that the court has to keep finding new bases to uphold the core tenets of Roe while disagreeing with the original premise, with that idea of looking towards the medical history and the medical legal history. And in fact, when you go back to 1990, to the Casey case, when you go back to that case and you see that the court was turning to the reliance interest to uphold Roe because they were trying to sort of grasp at straws almost and find a reason to uphold Roe. And it's hard for me to imagine, really, since Roe itself, a more anti-feminist decision and a more anti-feminist rationale. When you look at a court saying that women can't succeed on our own, that we can't succeed on a level playing field with men, that we rely upon abortion in order to compete with men in society and in the workforce, and in order to succeed and in order to plan our education and careers and family and future. I can't think of a more offensive idea than that. And so, as a post-abortive woman myself, and knowing my experience, knowing that in my case and in the case of so many women who I've counseled, I've comforted, I've represented, that the decision really wasn't one of choice, that we turned to abortion believing that there was no other choice, no better choice, and looking at the experience itself, how in my case and in the case of many others, our choice, our autonomy were stripped from us behind those doors, and the impact that it's had on our lives. I would say that it's not surprising. That it's not surprising when you have legal scholars on both the left and the right criticizing Roe and saying, well, maybe I agree with Roe as a policy decision, but I don't agree with it as a constitutional matter, because it really isn't based in the Constitution. When Justice Blackmun himself cited a string of cases as part of the precedent to decide Roe, and then a few short pages later said, well, but in fact, these are all quite different cases. It's a different situation, talking about marriage versus bodily autonomy. This is a decision that legal scholars on the left and the right, in so many cases, agree should be overturned, will be overturned, and we do believe that will happen, whether that's sooner or later.
Mary, and
Can I take issue with that? I cannot believe, this is the third time in the last 3 weeks I've been confronted with this view that it's not appropriate to recognize the right to make childbearing decisions as part of our Constitution. Our Constitution has had a long and distinguished history of giving both decisional autonomy and bodily integrity and protecting those rights by the highest level of constitutional protection. Now, yes, you're right, there has been whittling away, but it seems to me the millions of dollars being spent by the evangelical and Catholic Church spent trying to denigrate and take away the rights of women contributed to that. And you did a good job. I'll give you that. You did a good job, and we were not sufficiently vigilant to protect what we think is important recognition within our Constitution. But to say that it's illegitimate or not recognized or not appropriate to recognize the most fundamental rights to make decisions about your family, whether you marry, who you marry, whether you have sex, who you have sex with, whether or not you have a pregnancy and you want to carry it to term or you want to terminate that pregnancy, Whatever those decisions are, it seems to me, are fundamentally protected by the U.S. Constitution, and they ought to continue to be so.
Mary, I wanted to ask a broader question, going beyond the sort of mechanics about, how Roe may or may not be overturned. During the Justice Gorsuch and Justice Kavanaugh confirmation hearing, Roe was obviously a huge issue and was brought up multiple times. And so on the one side of the debate, you have state legislators and governors like Governor Ivey, who basically seem to have not accepted Roe or Casey as the law of the land, as settled law, and are continuing to challenge it, which strikes me as kind of almost questioning the Supreme Court in a way, and questioning those decisions. And on the other side, you have the critics of Justice Kavanaugh kind of criticizing the confirmation process and the legitimacy of the Supreme Court, as a result. And so if there were to be a decision, let's say, whether it's this term or next term, either striking down Roe or chipping away at it that was seen as pretty unpopular, could that lead to or contribute to criticisms of the court's legitimacy in any way, just because it's such a heated topic of debate?
Yeah, I think that it's a lose-lose. I mean, I think that we're at a point in American history where anything the court does about abortion is going to be perceived as political. And I think if you're someone like Justice Roberts who wants to be the hero of the story, it would be pretty appealing to do nothing or to do very little or to do things in a way that people don't understand. But I think that there's, I mean, really, I think if people are calling me in the media saying what happened, that's a win, right? I mean, and the undue burden test in some ways was that. People didn't know what it was. But I think it would be, I think if the court overturns Roe, and they say that they're overturning Roe, that could be politically costly for the court. There's lots of polling suggesting that people want abortion to remain legal. Polling on abortion makes abortion opinion in America sound conflicted. When you dig much further, Americans seem to like some abortion restrictions. Many don't, but many do. But when you get into the sort of legality or not, criminalization or not question, people seem to think that Roe should remain the law. So I think the clearer the court is about what it's doing, and the other thing we haven't talked about yet is there's a possibility, I think a remote possibility, but a possibility that the court will at some point recognize a right to life, which would result in nationwide criminalization. I don't think that's on the table soon, but there's some reason to think that could happen. I mean, Justice Gorsuch has had interest in natural law arguments that would kind of lend themselves to recognizing a right to life. I wouldn't be surprised if Justice Thomas was interested in that. I'm the person thinking that it's going to take a while to get to overturning Roe, so I'm not saying that's going to happen tomorrow, but that's another question too. I think that would be very controversial as well. So I think that's probably the single biggest variable in terms of predicting what the court will do and when, is the court's probably worry that there could be a backlash, especially if they do something kind of a very clear Clarence Thomas style kind of opinion overturning Roe. I think that's probably the only thing that would either slow down the train, but I think there's a real possibility that will happen. And it's also worth saying, occasionally at these kinds of events, people will ask, when will this be over? And the answer is never, right? So if Roe is overturned, you'll just see a kind of reverse of what happened when Roe came down, with the roles reversed, where you have the pro-life or anti-abortion movement defending a precedent, and you have the pro-choice or abortion rights movement attacking a precedent in court. The fight will come down to each state. Many states are in the middle. I live in Florida, which is the ultimate swing state. There'll be huge fights in places like Florida, and there'll even be fights, I think, in some ways in states like Alabama, because this wasn't consequential before, right? I mean, legislators in Alabama said simply, this is a vehicle to test Roe. We're not serious about enforcing this. But I think we'll expect to see the conflict intensify, not de-escalate, regardless of what happens.
Kathryn, what's your take on the legitimacy issue with respect to Roe? Was the legitimacy question when Roe was issued, or what will happen if Roe is struck down? How will that affect the court's legitimacy?
Well, certainly, as I mentioned before, we have seen legal scholars on both sides question the legitimacy of Roe. I think the clearest perspective on that recently has come from Justice Thomas, and in particular in one Section 1983 case relating to patients' rights to sue. And in his dissent from denial of certiorari, where the court decided not to hear the case, and he thought that the court should have, he spoke very clearly to his colleagues on the bench, saying, if this case weren't about abortion, if it were about any other matter, then we would have taken this case up. If one of the parties in the case wasn't named Planned Parenthood, we would have taken this case up. And I think that that could be written to really almost anyone on the court, because this is a case that should have been heard. You know, we need consistency in that idea of who can a patient sue? You know, when can a patient sue, and have a choice of medical provider, and the fact that the court didn't take that case is quite symptomatic of the court's current stance on abortion, and not having taken up some of these current cases. So, you know, we don't know when the court will take up a case again. On average, as of at least a couple of years ago, the court takes a case on abortion every 2.5 years or so. And so we do expect that there will be something soon, but we don't know exactly when that will be.
So let me address the legitimacy question. I am, as a lawyer, as a citizen, as somebody who cares deeply about the Constitution, I'm extraordinarily concerned that not only is both the confirmation process for justices and the continued view that the justices are partisan in many of their renderings, their willingness to overturn precedent very cavalierly in some of the most recent cases, all undermine the legitimacy of the court. And the legitimacy of our justice system is the most important aspect of what preserves our democracy. Because the judiciary is that balance, is that check on the other two branches of government. And so we need a court that is not only legitimate in fact, but is perceived to be legitimate as well. And until we return to a system in which partisanship and rancor and frankly, just talent is recognized in who's being appointed to the courts of this country, we're going to be in trouble, okay? And I think that is really problematic. It is not surprising to me, given how many norms, constitutional norms, are challenged and have been pushed to the limit by both the current administration and other things that have gone on in the last 10 years. But I think that legitimacy of the court is really, really important. I just want to say one more thing, and I can't be up here now tonight without recognizing the historic nature of today that has nothing to do with abortion. But for those of you who don't know, Nancy Pelosi announced that the House will begin an impeachment inquiry. That's an historic event in our nation, and we need a legitimate court to be able to handle what is going to go forward, not only around that issue, but about many, many other issues coming forward. And frankly, abortion is the least of it in many cases. You know, I would love to think my issue is the most important, but frankly, when we're talking about democracy, maybe that's more important than even abortion.
Thank you, Kitty. Actually, tomorrow, the Constitution Center is doing an event at the Atlantic Festival over the battle for the Constitution, and we'll have Representative Adam Schiff there, along with hopefully a counterpart, and we'll be talking about I'm sure, this issue. So you can tune in on the live stream if you're not able to be there in DC at the festival. So I want to get to some audience questions before we wrap up, because there's a lot and they're really good. So let's see how many we can do. So Mary, I'll start with you.
Sure.
This question asks, why do you think abortion is such a salient political, and I guess I'll add constitutional issue in America?
It's complicated. I think in part it's because there are people on both sides with, I think, sincere and really profound convictions. I think some of those are driven by morality, some of those are driven by personal experience, some of those are driven by religion, and those just aren't going to change anytime soon. The other reason I think this is true is because we have a political system where parties have aligned, there's an identifiably pro-life and identifiably pro-choice party. That was in no way historically inevitable, but once it happened, you had parties in some ways reinforcing existing social and political divisions about abortion for their own political gain. So quite often if you speak to people in Europe, they'll be puzzled about why abortion politics in America are the way they are. And I think some of it is that Americans themselves are genuinely divided about abortion, but some of it is because American politics has centered on abortion in a way that's fairly unique.
I would have a different answer to that, which is I think it's all about equality. I don't really think it's about a medical procedure at all. And it's about the affront that some people in our nation believe that women ought not to control decisions about having children. And frankly, decisions about their lives in many ways. So to me, misogyny is a huge part of this. It's the unspoken part of it. But if we were really just talking about a medical procedure, frankly, one of the safest medical procedures in the nation, we wouldn't be having this debate.
Kathryn, why do you think it's such a big political and constitutional issue?
Well, I would certainly agree that misogyny is a huge problem in America still. We see that through so many of our systems, and that's something that, that we fight against every day. The fact that we have to go to the Supreme Court to try to defend the rights of pregnant individuals. Young v. UPS, for example, it's a situation where we do have to fight every day for our rights. That said, that's not why I'm here. I'm here because I had this experience. I know how it impacted me. I'm here because I know that a society that says that I can't compete with a man without having legal access to abortion, that's a society that needs to change. I'm not the one, women are not the ones who need to change here if we cannot both have children, be pregnant, and simultaneously fully participate in society, fully participate in every aspect of our communities and our society and our nation. That is a nation that needs to reevaluate and start developing new ways for women to fully engage in our communities.
Kitty, I'll start with you for this one. What happened during the 1-month period that made Justice Kennedy change his mind to Casey?
I don't know. I've talked to a number of clerks who worked for him. I think twofold. One is once Justice Rehnquist wrote the opinion and he understood fully that full criminalization would have been permitted, he began to rethink how that would play in America. And I think it all comes down to his concern about the institutional integrity of the court. If nothing more, Justice Kennedy was always concerned with that and didn't want the court to be perceived as a body that would change based on who appointed a particular justice. That the rule of law was important and stare decisis was important, and clearly under the current rules of the rules of stare decisis that were applicable at the time of Casey, there was no reason to change the law unless you kind of abandoned those basic principles. So I think that's at the heart of it. There was also, I think, Justice O'Connor was very key in being able to help him through that. And her view, I think, while she adopted the undue burden test, the joint opinion in Casey was a much more protective undue burden test than Justice O'Connor had previously adopted. And I think that for her, it really was an understanding of what some women, particularly battered women, were going through when they faced unintended pregnancy. And that point of view, her kind of concentration on the facts there, helped Justice Kennedy understand that there are some circumstances in which criminalization would have been bad.
Mary, given the current composition of the court and the fact that this administration might have a third pick, how significant is the 2020 election to the future of Roe and Casey?
I think it's still significant. I mean, one of the things we're talking about, the legitimacy of the court, there have been a lot of proposals about changing the court, right? I mean, people have talked about term limits, people have talked about court packing. Clarence Thomas might, you know, it's always significant. I mean, I think it's not as significant, obviously, as Anthony Kennedy was. I mean, I call a lot of my courses the Anthony Kennedy farewell tour, because he was the deciding vote on everything, right? And so his departure was major in a way that almost nothing else could be. But I think it's still significant, in part because we're talking so much about even what the basic structure of the court should look like, and in no small part because of decisions like Roe. I think it's also significant just insofar as the court may be reading tea leaves about whether this issue matters to people, right? I mean, if we're talking about the court's potential angst about public reception to a decision, if abortion is clearly a major issue in the 2020 election, that sends a very different message than if, you know, there are many issues, e.g. impeachment, but if people are not as focused on abortion in their voting or not focused on it at all, that might not send the same signal to the court.
Kathryn, is it possible or reasonable to discuss, I know you mentioned the decrease in the number of abortions that have been occurring, without also talking about access to contraception, birth control, IUDs, and those sorts of issues?
Sure, there are many reasons why the abortion rate has decreased in America. Obviously, the CDC and other entities have been analyzing those. They include things like contraceptives. They include some of the laws that have been put into place. They include things like resources for pregnant women. Some of the centers that are out there, some of the governmental resources that we provide today that perhaps we didn't provide always in prior decades. Just a number of different ways in which we are increasingly reaching out to women and walking them through what can be a difficult and scary process. And so as we improve that, as we improve our community supports and our governmental supports, we're seeing increasingly, and as women similarly, as we see scientific advances, medical advances, things like ultrasounds, et cetera, women are increasingly able to pursue other avenues, whether it's parenting, whether it's placing a child in a home through adoption, or any of the other options, as well as preventing pregnancy.
So the Alan Guttmacher Institute has looked at this fairly carefully. Yes, we're at the lowest number of abortions. They are not able to say what that reason is. I agree with you on that. But I have to tell you that I do think increased access to contraception and the availability of contraception under Obamacare and the expansion of Medicaid in many states, given women greater access to family planning, is a big contributor, along with the fact that there's fewer women of childbearing age post the baby boomlet. But I think the important part here is that the current administration's just going backwards on all of this. They've enacted the gag rule. They're reducing women's access to contraception in a whole host of areas. They're reducing funding for Planned Parenthood. In my view, however you read the data, if you eliminate contraception to young women in America, you are going to increase abortions, whether legal or illegal. And we have an obligation to make sure that doesn't happen.
Well, we only have a couple minutes left, and there are so many more questions. I wish we could get to them all. But I want to close with one final question, which is the actual topic for debate. And the question is, and I'll start with you, Mary, should Roe versus Wade be overturned?
Oh, boy, as the historian on the panel, I feel bad answering this question. I think that, I don't think so, but I think there's also, I think, like I said, I think that this is going to be an endless process. So I think in some ways, if the only sort of maybe comforting message, if you don't want Roe v. Wade to be overturned, is it's not going to be over. So, Roe v. Wade is dead, long live Roe v. Wade. I mean, there'll be more of this to come. And I think, if you recall, after Roe, there was a sense that of complacency among the winners and a sense of people being fired up when they lost. I think that that'll be the historical moment we find ourselves in very soon. There are perils to winning. That's a lesson of history very much from the abortion debate.
Kathryn, same question to you. Should Roe versus Wade be overturned?
Roe v. Wade should be overturned. It is a decision that is not yet settled. We've seen that in the abortion cases through the subsequent decades. We've seen that in the opinions of legal scholars. We've seen that in the movement of Americans who oppose abortion and are continuing to fight back on this. We see that in all of the states where women and men are proposing and passing bills that would roll back Roe v. Wade, that would provide increased protections for women, that would in so many ways take away from that Roe regime of unlimited abortion. It should be overturned because it isn't firmly based in the Constitution, as we've seen from so many of these legal scholars who have said that, believe what you will about its policy elements. This is not a decision that finds its moorings in the Constitution. And so I do expect that it will be overturned sooner or later.
Kitty, last word to you. Should Roe versus Wade be overturned?
No. For a couple of reasons. First of all, I think it's very firmly and well grounded in our constitutional jurisprudence. There's no doubt in my mind about that. And every court that has looked at that question for the last 50 years agrees with that. So, to say it's not firmly based in the Constitution is just wrong. But more importantly, why shouldn't it be overturned? Because it seems to me fundamental questions about whether you have children or you don't, whether you are sexual, whether you are not, whether you marry and who you marry, ought to be left to the individual and not the state. And if you take that away from people, the biggest impact is that poor women, young women, women of color, women who live in rural areas, who live in states which have fewer resources, are going to suffer serious health consequences. Some of those women will die. Thankfully, not as many women will die today as they did in the days before Roe, but women will die if you recriminalize abortion. And that, to me, is an abomination, should never happen in our current society, and we must take every step we can to ensure that women have access to safe and legal medical procedures.
Thank you so much, Kitty Kolbert, Mary Ziegler, and Kathryn Glenn Foster for being here tonight, and thank you all for coming.
So, by the way,